The U.S. Supreme Court stated in the Tinker decision that neither students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. In this video, I'll first introduce what kind of educators' speech is protected and what is not. I'll first introduce the Pickering versus Board of Education, 1968. This case was about teachers' speech on issues of public importance. The U.S. Supreme Court's decision declared that public employees do not relinquish all of their free speech rights while working for the government. I'll then introduce the standards used in the Pickering decision. The standards came from the case New York Times Company versus Sullivan, 1964. In this case, the U.S. Supreme Court held that the freedom of speech protections in the First Amendment restrict the ability of American public officials to sue for defamation. The third case in this video is about an untenured teacher's termination of employment. A public employee refers to a person employed in a department responsible for conducting the affairs of a national or local government. The court has held that when a citizen becomes a government employee, the person takes on a dual status as an employee and a citizen, but often the employee's free speech right will be significantly less robust than those extended to citizens. In the Pickering case, a teacher named Marvin Pickering was dismissed from his position by the school board for sending a letter to a local newspaper. In his letter, the teacher was critical of the way in which the school board and the district superintendent had handled past proposals to raise new revenue for the schools. The teacher also expressed his view on a recently proposed tax increase and was critical of the superintendent who attempted to prevent teachers from opposing or criticizing the proposed bond issue. In February 1961, the school board asked the voters of the school district to approve a bond issue to raise $4,875,000 to build 2 new schools. The proposal was defeated. Then in December 1961, the board submitted another bond proposal to the voters, which called for the raising of $5.5 million to build 2 new schools. This second proposal passed, and the schools were built with the money raised by the bond sales. In May 1964, a proposed increase in the tax rate to be used for educational purposes was submitted to the voters by the board, and the proposal was defeated. Finally, in September 1964, a second proposal to increase the tax rate was submitted by the board. This second proposal was defeated again. It was in connection with this second proposal of the school board that the teacher wrote the letter to a local newspaper editor that led to the teacher's dismissal. Prior to the vote on the second tax increase proposal, the district teachers organization published articles in the local newspaper to urge the passage of the tax increase and stated that failure to pass the tax increase would result in a decline in the quality of education. A letter from the superintendent making the same point was published in the paper 2 days before the election and was submitted to the voters the following day. It was in response to those materials, together with the failure of the tax increase to pass, The teacher submitted the letter in question to the editor of the local newspaper. The school board claimed that the publication of the teacher's letter was detrimental to the efficient operation and administration of the schools of the district. The school board dismissed the teacher after a full hearing on the dismissal. At the hearing, the school board charged that numerous statements in the letter were false, and that the publication of the statements unjustifiably impugned the motives, honesty, integrity, truthfulness, responsibility, and competence of both the school board and the school administration. The board also charged that the false statements damaged the professional reputation of its members and of the school administrators. The false statements would be disruptive of faculty discipline and would tend to foment controversy, conflict, and dissension among teachers, administrators, the Board of Education, and the residents of the district. Testimony was introduced from a variety of witnesses on the truth or falsity of the particular statements in the letter with which the board took issue. The board found the statements to be false as charged. No evidence was introduced at any point in the proceedings as to the effect of the publication of the letter on the community as a whole, or on the administration of the school system in particular, and no specific findings along those lines were made. The teacher claimed that his writing of the letter was protected by the First and 14th Amendments. The case went to the U.S. Supreme Court, and the court, in an 8-1 decision, ruled in favor of the teacher. Justice Thurgood Marshall delivered the opinion of the court. Marshall wrote, "The theory that public employment, which may be denied altogether, may be subjected to any conditions, regardless of how unreasonable, has been uniformly rejected. At the same time, it cannot be gainsaid that the state has interests as an employer in regulating the speech of its employees that differ significantly from those it possesses in connection with regulation of the speech of the citizenry in general." The problem in any case is to arrive at a balance between the interest of the teacher as a citizen in commenting upon matters of public concern and the interest of the state as an employer in promoting the proficiency of the public services it performs through its employees. An examination of the statements in the appellant's letter objected to by the board reveals that they, like the letter as a whole, consist essentially of criticism of the board's allocation of school funds between educational and athletic programs, and of both the board's and the superintendent's methods of informing or preventing the informing of the district's taxpayers of the real reasons why additional tax revenues were being sought for the schools. The statements are in no way directed towards any person with whom appellant would normally be in contact in the course of his daily work as a teacher. Thus, no question of maintaining either discipline by immediate superiors or harmony among co-workers is presented here. Appellant's employment relationships with the board, and to a somewhat lesser extent with the superintendent, are not the kind of close working relationship for which it can persuasively be claimed that personal loyalty and confidence are necessary to their proper functioning. Accordingly, to the extent that the board's position here can be taken to suggest that even comments on matters of public concern that are substantially correct may furnish grounds for dismissal if they are sufficiently critical in tone, We unequivocally reject it. We next consider the statements in appellant's letter which we agree to be false. The board's original charges included allegations that the publication of the letter damaged the professional reputations of the board and the superintendent and would foment controversy and conflict among the board teachers, administrators, and the residents of the district. However, no evidence to support these allegations was introduced at the hearing. So far as the record reveals, Pickering's letter was greeted by everyone but its main target, the board, with massive apathy and total disbelief. The board must, therefore, have decided, perhaps by analogy with the law of libel, that the statements were perceived harmful to the operation of the schools. However, the only way in which the board could conclude, absent any evidence of the actual effect of the letter, that the statements contained therein were perceived detrimental to the interest of the schools was to equate the board members' own interests with that of the schools. Certainly, an accusation that too much money is being spent on athletics by the administrators of the school system cannot reasonably be regarded as perceived detrimental to the district's schools. Such an accusation reflects rather a difference of opinion between Pickering and the board as to the preferable manner of operating the school system, a difference of opinion that clearly concerns an issue of general public interest. In addition, the fact that particular illustrations of the board's claimed undesirable emphasis on athletic programs are false would not normally have any necessary impact on the actual operation of the schools beyond its tendency to anger the board. For example, Pickering's letter was written after the defeat at the polls of the second proposed tax increase. It could therefore have no effect on the ability of the school district to raise necessary revenue, since there was no showing that there was any proposal to increase taxes pending when the letter was written. More importantly, the question whether a school system requires additional funds is a matter of legitimate public concern on which the judgment of the school administration, including the school board, cannot, in a society that leaves such questions to popular vote, be taken as conclusive. On such a question, free and open debate is vital to informed decision-making by the electorate. Teachers are, as a class, the members of a community most likely to have informed and definite opinions as to how funds allocated to the operation of the schools should be spent. Accordingly, it is essential that they be able to speak out freely on such questions without fear of retaliatory dismissal. In addition, the amounts expended on athletics, which Pickering reported erroneously, were matters of public record on which his position as a teacher in the district did not qualify him to speak with any greater authority than any other taxpayer. The board could easily have rebutted appellant's errors by publishing the accurate figures itself, either via a letter to the same newspaper or otherwise. We are thus not presented with a situation in which a teacher has carelessly made false statements about matters so closely related to the day-to-day operations of the schools that any harmful impact on the public would be difficult to counter because of the teacher's presumed greater access to the real facts. Accordingly, we have no occasion to consider at this time whether, Under such circumstances, a school board could reasonably require that a teacher make substantial effort to verify the accuracy of his charges before publishing them. What we do have before us is a case in which a teacher has made erroneous public statements upon issues then currently the subject of public attention, which are critical of his ultimate employer, but which are neither shown nor can be presumed to have in any way either impeded the teacher's proper performance of his daily duties in the classroom or to have interfered with the regular operation of the schools generally. In these circumstances, we conclude that the interest of the school administration in limiting teachers' opportunities to contribute to public debate is not significantly greater than its interest in limiting a similar contribution by any member of the general public. The public interest in having free and unhindered debate on matters of public importance, the core value of the free speech clause of the First Amendment, is so great that it has been held that a state cannot authorize the recovery of damages by a public official for defamatory statements directed at him, except when such statements are shown to have been made either with the knowledge of their falsity or with reckless disregard for their truth or falsity. Justice Marshall used the standards of New York Times Company versus Sullivan 1964 case to reach the conclusion that the same test has been applied to suits for invasion of privacy based on false statements where a matter of public interest is involved. It is therefore perfectly clear that were appellant a member of the general public, the state's power to afford the appellee, Board of Education, or its members any legal right to sue him for writing the letter at issue here would be limited by the requirement that the letter be judged by the standard laid down in New York Times. Justice Byron White, concurring in part and dissenting in part, he agreed that Pickering's discharge must be tested by the standard of New York Times Company versus Sullivan, 1964. But Justice White preferred to remand the case for further proceedings to decide whether the statements in the letter were knowingly or recklessly false. He wrote, "I find it wholly unsatisfactory for this court to make the initial determination of knowing or reckless falsehood from the cold record now before us. It would be far more appropriate to remand the case to the state courts for further proceedings in light of the constitutional standard, which the court deems applicable to this case, once the relevant facts have been ascertained in appropriate proceedings." So, what was the New York Times Company versus Sullivan about? It was a U.S. Supreme Court decision that the freedom of speech protections in the First Amendment restrict the ability of American public officials to sue for defamation. What's defamation? If your reputation is damaged, you can claim injury and be awarded damages for written or spoken injury. But if you are a public official, or you are running for public office, you are held to a higher standard for what you must prove before you may succeed in a defamation lawsuit. You must prove the normal elements of defamation, that is, publication of a false defamatory statement to a third party. You must also prove that the statement was made with actual malice. Here, actual malice is a legal requirement imposed upon public officials or public figures when they file lawsuit for libel, that is, defamatory printed communications. actual malice means the existence of rivalry, ill will, or hostility between the parties, and the defendant either knew the statement was false or recklessly disregarded whether or not it was true. The case began in 1960 after the New York Times published a full-page advertisement entitled "Heed Their Rising Voices." The advertisement criticized the police in Montgomery, Alabama, for their mistreatment of civil rights protesters. However, the advertisement had several factual inaccuracies, such as the number of times Martin Luther King had been arrested during the protests, what song the protesters had sung, and whether or not students had been expelled for participating. L.B. Sullivan was one of the 3 elected commissioners of the city of Montgomery, Alabama. He was Commissioner of Public Affairs. Part of his duties were to supervise the police department. Sullivan sued the Times in the local county court for defamation. The judge ruled the advertisement's inaccuracies were defamatory, and the jury returned a verdict in favor of Sullivan and awarded him $500,000 in damages. The Times appealed the verdict to the Supreme Court of Alabama, which affirmed it. It then appealed to the U.S. Supreme Court. In 1964, the Supreme Court issued a unanimous decision holding that the Alabama court's verdict violated the First Amendment. Justice William Brennan delivered the opinion of the court. A state cannot, under the First and 14th Amendments, award damages to a public official for defamatory falsehood relating to his official conduct unless he proves actual malice, that the statement was made with knowledge of its falsity or with reckless disregard of whether or not it was true or false. Factual error, content defamatory of official reputation, or both, are insufficient to warrant an award of damages for false statements, unless actual malice is alleged and proved. Justice Brennan wrote, "The constitutional safeguard we have set was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people, the maintenance of the opportunity for free political discussion to the end that government may be responsive to the will of the people, and that changes may be obtained by lawful means, an opportunity essential to the security of the Republic, is a fundamental principle of our constitutional system." The First Amendment, said Judge Learned Hand, presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and always will be folly, but we have staked upon it our all. Mr. Justice Brandeis gave the principle its classic formulation. Those who won our independence believed that public discussion is a political duty, and that this should be a fundamental principle of the American government. They recognized the risk to which all human institutions are subject, but they knew that order cannot be secured merely through fear of punishment for its infraction, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsels is good ones. believing in the power of reason as applied through government discussion, they eschewed silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of governing majorities, they amended the Constitution so that free speech and assembly should be guaranteed. Thus, we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The constitutional protection does not turn up on the truth, popularity, or social utility of the ideas and beliefs which are offered. As Madison said, some degree of abuse is inseparable from the proper use of everything, and in no instance is this more true than in that of the press. In a different case, the U.S. Supreme Court declared that in the realm of religious faith and in that of political belief, sharp differences arise. In both fields, the tenets of one man may seem the rankest error to his neighbor. To persuade others to his own point of view, the pleader, as we know, at times resorts to exaggeration, to vilification of men who have been or are prominent in church or state, and even to a false statement. But the people of this nation have ordained, in the light of history, that in spite of the probability of excesses and abuses, these liberties are, in the long view, essential to enlightened opinion and right conduct on part of the citizens of a democracy. As Madison said, the censorial power is in the people over the government, not in the government over the people. It would give public servants an unjustified preferences over the public they serve if critics of official conduct did not have a fair equivalent of the immunity granted to the officials themselves. After introducing the New York Times Company versus Sullivan case, let's go back to the Pickering case. In the Pickering decision, the U.S. Supreme Court applied the standard of actual malice. The Supreme Court also established a balancing test to determine whether the First Amendment protects a public employee's speech. A balance must be achieved to protect a public employee commenting on matters of public concern and a public employer's concern in promoting workplace efficiency. Since the Pickering decision in 1968, the court has further elaborated on the applicable requirements, holding that government employees enjoy First Amendment protections only when speaking as private citizens and on matters of public concerns. The third case we look at in this video is about an untenured teacher's termination of employment. Fred Doyle was an untenured teacher. He was first employed by the school board in 1966. He worked under one-year contracts for the first 3 years and under a 2-year contract from 1969 to 1971. In 1969, he was elected president of the Teachers Association, in which position he worked to expand the subjects of direct negotiation between the association and the Board of Education. During Boyle's one-year term as president of the association and during the succeeding year when he served on its executive committee, there was apparently some tension in relations between the board and the association. Beginning early in 1970, Doyle was involved in several incidents not directly connected with his role in the Teachers Association. In one instance, he engaged in an argument with another teacher, which culminated in the other teachers slapping him. Doyle refused to accept an apology and insisted on some punishment for the other teacher. His persistence in the matter resulted in the suspension of both teachers for 1 day, which was followed by a walkout by a number of other teachers, which in turn resulted in the lifting of the suspicions. On other occasions, Doyle got into an argument with employees of the school cafeteria over the amount of spaghetti which had been served to him. Doyle used profanity when he referred to students. Doyle also made an obscene gesture to two girls in connection with their failure to obey commands made in his capacity as cafeteria supervisor. In another incident, Doyle made a phone call to a local radio station. It was the board's consideration of this incident that made it to the court. In February 1971, the principal circulated to various teachers a memorandum relating to teachers' dress and appearance, which was apparently promoted by the view of some in the administration that there was a relationship between teacher appearance and public support for bond issues. Doyle called a radio station. In the call, Doyle conveyed the substance of the memorandum, and the radio station announced the adoption of the dress code as a news item. Doyle later apologized to the principal, conceding that he should have made some prior communication of his criticism to the school administration. About 1 month later, the superintendent recommended to the school board that Doyle not to be rehired. The board adopted the recommendation. Shortly after being notified of this decision, Doyle requested a statement of reasons for the board's actions. He received a statement citing a notable lack of tact in handling professional matters, which leaves doubt as to your sincerity in establishing good school relationships. The general statement was followed by the references to the radio station incident and the obscene gesture incident. Doyle then brought this action against the school board for reinstatement and damages, claiming that the school board's refusal to rehire him violated his rights under the First and 14th Amendments. The district court held that the phone call was clearly protected by the First Amendment, and that because it had played a substantial part in the decision not to rehire Doyle, he was entitled to reinstatement with back pay. The Court of Appeals affirmed. The U.S. Supreme Court unanimously agreed that the teacher's phone call to the radio station was protected by the First and 14th Amendments, but the Supreme Court held that the school board's consideration of the phone call in itself did not violate Doyle's rights. Justice Rehnquist delivered the opinion of the court. Rehnquist wrote, "The long-term consequences of an award of tenure are of great moment both to the employee and to the employer. They are too significant for us to hold that the board in this case would be precluded because it considered constitutionally protected conduct in deciding not to rehire Doyle from attempting to prove to a trier of fact that, quite apart from such conduct, Doyle's record was such that he would not have been rehired in any event." Justice Rehnquist held that the district court should have determined whether the school board showed by a preponderance of evidence that it would have reached the same decision if it had not considered Doyle's phone call to the radio station. But the Supreme Court's decision on this case has been criticized as allowing public employers to circumvent restrictions on taking adverse action against whistleblowers. In this video, I introduced 3 cases on teachers' freedom of expression. The first case, Pickering versus Board of Education, was about teachers' speech on issues of public importance. The U.S. Supreme Court's decision declared that public employees do not relinquish all of their freedom speech rights while working for the government. I then introduced the standards used in the Pickering decision. The standards came from the case New York Times Company versus Sullivan. This case was a U.S. Supreme Court's decision that the freedom of speech protections in the First Amendment restrict the ability of American public officials to sue for defamation. The third case in this video was about an untenured teacher's termination of employment.